Hello and welcome. I'm Lena Wynn, a divorce lawyer here in Texas, and today we're going to dive deep into one of the most effective methods of resolving divorce disputes. That's mediation and alternative dispute resolution, also known as ADR. If you're going through a divorce or you just want to understand how mediation works, this video is for you. Before we start though, I want to remind you that the information shared in this video is for general educational purposes only. It is not legal advice. For advice specific to your situation, please consult a licensed attorney. Now let's get started. What is mediation? Well, mediation is a process in which a neutral third party, also known as a mediator, helps two parties in a dispute come to an agreement. In divorce cases, mediation is one of the most common forms of alternative dispute resolution, or ADR. It's used to resolve disagreements between spouses without going to trial. Whether it's dividing assets, determining child custody, or figuring out spousal support, mediation offers a way for couples to work through their issues more amicably. So why should you consider mediation in your divorce? Well, let's take a closer look at some of the benefits. One of the biggest benefits of mediation is that it is cost effective. Divorce trials can be expensive. You have court fees, lawyer fees, and other associated costs that can add up quickly. Mediation, on the other hand, is typically less costly as it generally involves fewer hours and less preparation. Another advantage is that mediation can help you reach a faster resolution. Court cases can drag on for months or even years, but mediation allows you to potentially resolve your issues in a matter of weeks or a few sessions. This is particularly beneficial if you're trying to avoid the lengthy legal battle and want to move on with your life. Now, perhaps most importantly, mediation gives you and your spouse control over the outcome. In court, a judge will make the final decision, but with mediation, you can work together to find solutions that are mutually agreeable. This can lead to a more positive post-divorce relationship, which is especially important if children are involved. And finally, mediation is a private and confidential process. Everything discussed during mediation remains confidential and can't be used in court later on. This gives you the freedom to openly discuss issues and concerns without worrying about the consequences in front of a judge. Now that we know why mediation can be beneficial, let's break down how the process works here in Texas. While the specifics may vary slightly depending on the mediator and the circumstances, here's a general overview of what you can expect to happen. First, both parties need to agree to mediate. This is typically part of the divorce process in Texas, but it's important to note that both spouses must be willing to participate. If one spouse refuses mediation, the court may still order it, but it's usually more effective when both people are willing to negotiate. And once both parties agree, you'll typically choose a mediator. Mediators are trained professionals, often lawyers or retired judges, who are skilled at facilitating negotiation. In Texas, mediators must be certified by the Texas Mediator Credentialing Association or a similar body to ensure that they are qualified. The mediation session. On the day of mediation, you and your spouse, along with your respective attorneys if you choose to have them present, will meet with the mediator in a neutral setting, such as a conference room. The mediator will explain the rules and guidelines of the session, including confidentiality and the voluntary nature of the process. Generally, the mediation session is structured in a way that each party has the opportunity to speak about their concerns. The mediator may choose to hold separate meetings with each side, known as a caucus, where they can discuss issues privately. This gives both parties the chance to express their needs and frustrations without directly confronting one another. During mediation, the mediator doesn't make any decisions for you. Instead, they can help guide the conversation and assist both parties in understanding each other's positions. They might suggest potential solutions, but ultimately, it is up to you and your spouse to agree on the terms. What to expect during mediation. Here are a few things you can expect during the mediation process. First, you should stay calm and open-minded. Mediation is about finding common ground, not about winning or losing. It's important to remain respectful and focus on reaching an agreement that works for both parties. Preparation is key. Before the session, it's important to gather all necessary documents such as financial records, property inventories, and any relevant information that will help you understand your situation. Being prepared will help the process go more smoothly and increase your chances of reaching a fair agreement. Also, make sure you understand your rights before entering mediation. While a mediator can help guide the discussion, they are not giving legal advice. If you're unsure about what you're entitled to, it's a good idea to consult your attorney before the session. And of course, negotiation and compromise are essential parts of the process. The goal of mediation is to find a resolution that works for both parties, and sometimes that requires making concessions. Keep in mind that while you may not get everything that you want, mediation offers a better chance of finding a solution than going to trial. After the mediation session, if both parties come to an agreement, the mediator will draft a mediation agreement. This document outlines all of the terms that the parties have agreed upon. It is then signed by both parties and, in many cases, presented to the court for approval. Once approved, the agreement becomes legally binding. When mediation doesn't work. Unfortunately, not all mediation sessions are successful. If the parties can't reach an agreement, the divorce will likely proceed to trial. However, even in this case, mediation can still be beneficial. Many times, mediation helps narrow down the issues that need to be resolved, making the trial process quicker and less contentious. While mediation has proven to be a valuable tool in many divorce cases, it's important to understand that it's not always the best option for every situation. Let's take a deeper look at some of the scenarios where mediation might not work and when you might want to consider other forms of dispute resolution. One of the main reasons why mediation may not work is if there is a history of abuse or domestic violence in the relationship. If one party feels threatened or unsafe, mediation is not a safe or effective option. In these cases, it is important to seek the guidance of an attorney and consider alternative legal remedies such as seeking a protective order. Another situation where mediation might not be effective is where there are high levels of conflict between the parties or one spouse is simply unwilling to participate in the process. Mediation requires cooperation and the ability to negotiate. If one party is unwilling to engage in a meaningful dialogue or is only interested in winning, the process will likely fail. Similarly, power imbalances, whether due to financial control, emotional manipulation, or other factors, can undermine the mediation process. If one party feels dominated or bullied by the other, they might not feel comfortable advocating for their interests. In such cases, it may be necessary to have legal representation or to proceed with a different form of dispute resolution. Lastly, complex legal issues that require deep legal expertise, such as significant financial complexities, high-value assets, or complicated child custody arrangements, may not be best suited for mediation. If the issues at hand require an in-depth understanding of the law or specialized legal knowledge, litigation may be necessary. That being said, there are several types of alternative dispute resolution, or ADR, processes that can help resolve your divorce in a less contentious way than litigation. Let's explore a few of those options. While mediation is the most common form of ADR in divorce cases, there are other options available that might be more appropriate depending on your situation. Let's start with arbitration. Unlike mediation, where the mediator helps guide the conversation but doesn't make decisions, arbitration involves a neutral third party who has the authority to make binding decisions on the issues at hand. Essentially, arbitration is like a private trial where the parties present evidence and arguments and the arbiter makes a decision. Arbitration can be faster and less expensive than a court trial, but unlike mediation, it doesn't allow you to maintain control over the outcome. If you and your spouse are unable to agree on key issues, arbitration might be a better option than mediation, especially if you want a quicker resolution but still need a third party to make a final decision. Another form of ADR is collaborative divorce. This method involves both spouses working with their respective attorneys along with other professionals like financial planners or child specialists to resolve divorce issues in a cooperative manner. The goal is to reach a mutually beneficial settlement through open communication and negotiation while avoiding the courtroom. In a collaborative divorce, both parties sign an agreement committing to the process and agreeing not to go to court. If the process breaks down and the parties are unable to reach a settlement, the collaborative attorneys withdraw, and then the parties must seek new counsel for litigation. This can provide a strong incentive for both parties to work together towards a resolution. Collaborative divorce is best suited for couples who want to maintain a civil relationship, especially when children are involved, and is effective in cases that don't involve high levels of conflict. The third form of ADR we'll discuss today is early neutral evaluation, also known as E&E. In E&E, both parties and their attorneys meet with a neutral expert, typically an experienced family law attorney or a retired judge who evaluates the strengths and weaknesses of both sides' cases. The evaluator would then offer an informed opinion about how the case might be resolved if it were to go to trial. While the evaluator's opinion is not binding, it can provide valuable insight into the likely outcome of a case and help both parties better understand their positions. E&E is particularly helpful when there are complex financial issues or when one or both parties are unsure about the strength of their case. It can help guide settlement negotiations and avoid protracted litigation. Preparing for mediation, what you need to know. Now let's get back to mediation. To give you the best chance of success, it's essential to come prepared. Here's how you can prepare for a mediation session. First, gather all financial documents. This includes income statements, tax returns, bank statements, and any other relevant documents that reflect your financial situation. In divorce, especially when it comes to dividing assets or determining spousal support, full financial transparency is crucial. This helps you understand what is at stake, and it will help you make informed decisions during the mediation. Next, it's important to list your priorities. Think about what matters most to you, whether it's a particular asset, custody of your children, or a fair financial settlement. Prioritizing your goals will help you stay focused during your mediation session and ensure you don't get sidetracked by smaller, less important issues. Finally, you need to be ready to compromise. Mediation isn't about getting everything you want, but about finding a solution that works for both parties. Sometimes this requires making difficult decisions and concessions. The more flexible and open-minded you are, the better the chances of reaching a resolution. The role of attorneys in mediation. Now you might be wondering, do I need an attorney for mediation? The answer is, it depends. While you can technically go through mediation without an attorney, having one can significantly improve your chances of reaching a fair agreement. Here's how an attorney can help. Your attorney can provide legal advice before, during, and after the mediation session. Before mediation, they can help you understand your rights, the potential outcomes, and what you should prioritize. During mediation, your attorney can provide support and guidance, helping you assess offers, identifying legal issues, and ensure that the agreement is in your best interest. Finally, after mediation, your attorney can review the final agreement to ensure it aligns with your legal rights and obligations. Common issues resolved in mediation. Many different issues can be resolved through mediation, including division of assets, which means property, retirement accounts, real estate, and other assets can be divided based on mutual agreement without needing a judge's involvement. Child custody and support. Parents can work out arrangements for custody and visitation, as well as child support payments without going to trial. Spousal support or alimony. The parties can negotiate how much spousal support, if any, will be awarded and for how long. Mediation offers the opportunity to resolve these issues in a way that works for both parties, rather than leaving it up to the court. Mediation is often a healthier, more collaborative approach to divorce, but it's not always easy. It requires patience, communication, and a willingness to compromise. Whether you're dealing with complex financial issues, child custody, or spousal support, mediation allows you to resolve your divorce on your own terms, with a third-party facilitator helping you work through your differences. So if you're going through a divorce and considering mediation, it's important to weigh the benefits and potential challenges. While it's not a guaranteed solution for every case, it can help save you time, money, and emotional stress, while allowing you to take control over your future. Let's quickly recap what we've covered today. The benefits of mediation: cost-effective, faster resolution, control over the outcome, and privacy. How the process works in Texas: agreement to mediate, selecting a certified mediator, and the structured session. What to expect: preparation, staying calm, understanding your rights, and being ready to negotiate. When mediation doesn't work: sometimes mediation fails, but it can still narrow down issues before trial. I hope this video has been helpful for anyone considering mediation in a divorce. Remember, mediation isn't just about avoiding court, it's about finding solutions that work for both parties and ultimately for any children involved. Thanks for watching. If you found this video helpful, don't forget to like, comment, and subscribe for more divorce-related tips and legal advice. And as always, if you're going through a divorce and need personalized guidance, feel free to reach out to me or another qualified attorney in your area. Best of luck.